Out of the Supreme Court registry, Attorney General Paul Kihara will not be opposing the petition filed by Azimio la Umoja One Kenya Party presidential candidate Raila Odinga and his running mate Martha Wangare Karua at the Supreme Court. Kihara has filed a notice before the court through Solicitor General Kennedy Ogeto indicating his position. This will be the first time an Attorney General is not supporting the Independent Electoral and Boundaries Commission in a petition seeking to nullify the presidential results. The Attorney General is the principal legal advisor to the government. This is coming on the backdrop of Odinga having been President Uhuru Kenyatta's preferred presidential candidate in the just concluded elections. Charles, as I understand it, the Attorney General in the previous Raila 1, I think in the legal fraternity referred to the presidential petitions from 2013, 2017 as Raila 1, Raila 2. It's my understanding that the Attorney General sought to be enjoined as a friend of the court?
Yes, that is correct.
So what do you make of his opting out, or rather his decision not to oppose the petition filed by Raila Odinga and Martha Karua?
First, the Attorney General is not a necessary party in any election petition in the Republic of Kenya. Dozens of election petitions are filed, and the Attorney General ordinarily is not a party. But for the presidential election petition, because of the stakes involved, previously the Attorney General has applied to be joined as a party, normally as amicus. Amicus curiae is meant to be a friend of the court, not someone who is partisan and openly taking one position or the other, but someone who comes to assist the court on matters of the law or other technical matters that are subject to the proceeding. So for me, it is not strange that the Attorney General decides either not to participate or not to take a position one way or the other. In fact, that should be the norm.
Okay. So he is not opposing. Does that translate to his sitting out?
I don't know exactly what he intends to do. We'll wait to read his statements that have been filed in court. What I know is that he was not a party in petition number 5, which is the one filed by the Azimio team, but he was put in as an interested party in one or two of the other petitions. So he had to file some papers, and if he decided he doesn't want to participate, that means he's sitting out, or he may just show up to tell the court that I'm not taking a position one way or the other.
Okay. So I mean, I keep using the word explosive because I don't know how else to capture what I read in those affidavits by the 7 IEBC commissioners. Who is IEBC in this instance, if every single one of them is a respondent?
I think there has been a breakdown in the institutional integrity of IEBC. It's unfortunate. We are seeing it develop right before our eyes. So you notice that the petitioners, including the Azimio team, because they were aware of this initial breakdown in the institutional integrity of IEBC, sued both IEBC and each of the petitioners individually. And this is not normal, because in previous election petitions, you only sue the institution plus the returning officer of that election. That is the norm. So when you look at Raila 2013, Raila 2017, it's only IEBC and the chair of IEBC who were joined as respondents in the petition. But this time, because they were able to foresee that there is a difference of opinion, they joined each of the petitioners. So this was an invitation to the petitioners. They've taken it and grabbed it with all their energy, and they've all filed separate documents. 3 petitioners opposing the petition, the other 4 very ambivalent, not openly supporting the petition, but undermining the response of the returning officer. So that is what has happened, and each of them has filed their responses on the basis of the way they have been sued as individual respondents. I have not seen any document filed on behalf of IEBC, the first respondent, yet. And I don't know whether IEBC has been able to next documents where...
Are they equal when she says they're the majority, 4 versus 3? But are the commissioners equal, or does the chair, the office of the chair, have more weight?
So the answer to both questions is yes, which is surprising. All commissioners are equal. The moment they're in the deliberative body and they are seated and they are discussing the agenda, they have been duly constituted, they have equal weight. And you just need 4 commissioners to make a decision on behalf of the commission. But the chair has 2 important roles that the other commissioners do not have. The first role is that he's a returning officer of the presidential election based on Article 138, paragraph 10 of the Constitution, as supported by the Gazette notice that is always issued before every general election, confirming that he's a returning officer of the presidential election. As the returning officer, he has the role that all other returning officers have for the other seats. The second role that the chair has, different from the other commissioners, is as the chair of the commission, has the role to convene the commissioners and to determine the agenda of the meetings and when the meetings will take place. So the second schedule of the IBC Act says it is the chair to convene the meeting, to decide when the meeting will take place. But it gives 1/3 of the commissioners or 3 of the commissioners the right to requisition for a meeting. Only that the second schedule says once they requisition, it is the chair to convene the meeting. So what happened in this case is that 4 commissioners requisitioned for a meeting. Before the chair could convene, they said the chair ignored. They chose to convene the meeting themselves, led by the vice chair. And the vice chair then chaired that session, because under the IBC Act, in the absence of a chair, the vice chair can chair. But the chair was present. It's just that he had not convened that particular meeting. So that's part of the chaos. It's a breakdown of good governance. It is a sign that this IBC that stuck together until the day of the declaration of results for presidential election is now, it seems, irreversibly split, and we need intervention from external forces or sources to enable us